Welcome, resort professional community. You are welcome to Resort Trades Learning Center. I'm Sharon Scott Wilson. I'm publisher of Resort Trades magazine. And we also publish a weekly online e-publication, Resort Trades Weekly. So go to resorttrades.com to sign up for that or for either of them. Now, our topic today is Florida's new condo safety law, also known as Senate Bill 4D. If this is of interest to you, we're thrilled really to have our special guest, Scott MacGregor. Scott is Executive Vice President and Chief Operating Officer of Lemonjuice Solutions. So Scott is going to fill us in. Welcome, Scott.
Thank you very much, Sharon. It's always a pleasure to spend some time with you, of course, but it's, I think, a real special privilege to be able to talk to your readers and the community about this particular issue, because I think it's going to be extremely impactful on an awful lot of people, and as we'll talk about, timeliness is really key to success here. So thank you for the opportunity.
Yeah, well, it's obviously going to be a very huge problem for a lot of people. So it's good to get an earlier start as possible. So can you explain briefly how the new law came about, when it was enacted?
Okay, sure. And what we're talking about specifically is the body of law created by Senate Bill 4D, Florida Senate Bill 4D, which was passed into law here in the state of Florida, signed by Governor DeSantis in May of 2022. So it's coming up on already a year old. And it's really a very broad set of laws that was designed to try to mitigate risk and prevent additional damages after the collapse of the Champlain Towers resort building down in Surfside, Florida, that everybody remembers. Just a couple of years ago, nearly 100 people were killed and damages of $1 billion eventually levied against the participants and stakeholders in that. So this bill was passed in the wake of that tragedy to do a couple of things. Number one, to try to address the issues that affected Surfside or Champlain Towers specifically, which is the aging infrastructure, particularly among these concrete buildings that dot the Florida coastline. So it's really done to try to fix and address and identify those buildings that have the same type of structural weaknesses. It is also a risk management measure in that it's intended to try to bring some relief, if you will, to the property insurance markets. Anyone that has had to pay an insurance premium here in the state of Florida for property insurance in the last year is aware that we're seeing premium increases of 25 to 400 or 600%. And these are dramatic raises in what is often one of the biggest line items in a property's budget, the property and wind insurance. And so obviously the insurers are trying to build into their risk models the effects. Like I say, it was $1 billion of total settlement with Champlain Towers alone. So this bill is intended to prevent and identify the issues that led to the collapse, but also to try to bring some certainty to the property insurance markets that something's being done to prevent further losses like that which occurred previously.
Now, where can people go to learn more about this? I think you have some deeper resources.
That's a great question, because when we started here, we put up a slide that we at Lemonjuice are actually holding a series of after-hours events around the state of Florida to try to work within the communities and help educate as to the impact of these laws and how they can start to address them. Our first one will be in Daytona Beach Shores on Thursday, May 11th at 4:30, and we'll put some information up at the end of our discussion today, where you go to our website, lemonjuicesolutions.com, and click on the SB4D link, and it'll take you to a place where you can register for that event. And as I said, we'll be holding others in different parts of the state. There's also lots of online resources here, and it's absolutely critical that anybody that has an interest in a piece of real estate in Florida or affected by the law goes and finds that information. As I said, we're talking about Senate Bill 4D, and you can still find the text of that. You just go to flsenate.gov and type in SB4 or SB4D, and you'll get to it. And I encourage you to download or print out the 86 pages of the bill, because it's very far-reaching. It actually affects 6 or 7 different bodies of law in the state. It specifically addresses Florida Statute 553 about construction. It really starts off talking about changes in the interpretation of the construction codes as it relates to roofs, but other structural elements. But it also modifies, like Chapter 468, which talks about professional designations and who's not only capable of participating in the performance of the studies that we're going to talk about, but who is also affected by them. And it makes very clear that it's not just the boards of directors that we'll talk about that are implicated and required to take action, but their management entities as well. It affects the 4 real estate statutes that many of us practice in Florida are familiar with. 718, which is the condominium law, 719, which affects cooperatives, 720 for homeowners associations, and even 721 that is specifically regarding timeshare. All of those statutes are affected by the provisions of the Senate Bill 4D. So that's what I encourage people to do, is go online and get the document itself and take some time to read through it. But do come visit with us in Daytona or any of our future locations, and we'd love to talk with you more about it.
Oh, that's it sounds so involved and complicated. So, Scott, I'm so glad that you are making a really intense study of this. I'm going to, what are the basic milestones? And then as people read through this, you can allude to it.
Certainly. The first milestone, which isn't listed here, is actually already passed. By December 31st of 2022, all managers or associations that may potentially be impacted by this law were to have filed a report with the Florida Divisions of Business and Professional Regulations to indicate that they are in a building that may be subject to the law. And it's a very simple report. It asks, the location of the building, how many stories it is, and if it's more than 3 stories, how many units there are. And it's really important that everybody do file that report. It's the way that the state is making sure that it's taken a comprehensive inventory of all the buildings that may be subject to it. And it's not too late to do it. It's very easy. You can just log on to myfloridalicense.com, which is the DPBR website. And in the search bar, just type Milestone study or structural integrity study or even SB4D, and it will bring you to the page where you can fill out and submit the form. So that milestone is actually already passed, but if you haven't complied, don't let it go on any longer. A lot of the law in the introduction talks about its applicability, and it's intended to apply to every condominium building over 3 stories in the state of Florida, but specifically to really start targeting the older buildings that really need this evaluation done sooner rather than later. And it requires that on the 30th anniversary of the certificate of occupancy that the association perform the milestone inspection. And if the building came online prior to the year 1992, it's required that milestone inspection be completed by December 31st of 2024. So the end of next year, coming into our horizon here very, very quickly. And then they'll have to reperform that inspection every 10 years thereafter. If the building is located within 3 miles of the coastline, that time frame is actually shorter. You still have until, if you haven't filed one already, until December 31st, 2024. But the law is going to require that within 25 years of the certificate of occupancy, you've done the initial milestone structural study and started to work on the structural inspection reserve study, the SIRS milestone. And like I say, both of those right now correspond to December 31st, 2024. So you have to have had the phase 1 study completed by December 31st, 2024. Once you file the form that I recently alluded to online, you'll probably get a notification from a local building official that you're required to complete the milestone study. And you'll have 180 days from that notice to go ahead and complete it. So, like I say, between now and the end of 2024, everybody's going to be looking for an engineer to get that milestone study completed. Then you'll be required to get what's called start a structural inspection reserve study. And that requires an engineering or architectural report that is then incorporated into the association's reserve study and plan, and we can talk about that more. The initial structural study that you're going to have done is a non-invasive study. It's called a phase 1 study, and it's intended to look at all the public and non-public parts of the building and to see, number one, is there damage to the structural components that requires more research? So that's the first and important thing it's trying to identify. Are there problems with any of the structural members, the beams, the slabs, the foundation, any of the structural components, or as we talked about, or we will talk about, the major mechanical functions of the property, and it's done on a visual inspection. And if it's determined that a phase 2 inspection is needed to determine the extent of structural weaknesses, then that needs to be commenced right away. And that's a more invasive, where they may do destructive testing. They may drill or bore into structural members to test and examine their integrity, or to dig around foundations and things of that nature. And then any repairs that are indicated by that phase 2 report must be completed within 365 days of that report. So again, that December 31st, 2024 is really kind of the date to have this stuff ready and then to be ready to start implementing it. In the year 2024, all associations will be required to fully fund their reserve account as indicated by that structural integrity reserve study. And we can talk a little bit more about that. Those are the major milestones. Get the report filed with the division now, hire an architect now to get that phase 1 milestone study completed, and then start working on the structural integrity reserve study. And you may find that it's the same engineering firm that can do both for you, or you may find it's 2 separate engagements. So the time's now to start planning for that 12/31/24 deadline.
Yeah, wow. kind of scary. So what happens to boards who fail to comply with the new law?
It's a good question. We know that boards already have a fiduciary obligation to their associations to both follow the law, comply with regulations, and do what's in the best interest of their owners. And by extension, managing agents are already required to do that. If you read the bill, if you read SB 4D, it really becomes clear quickly that they are making it a significant violation if you aren't aware of the provisions of the bill and if you don't take the steps to implement it as it's intended when it's intended. And it says a number of times throughout the bill that a violation of any of the provisions of the bill will be considered to be a violation of the board and managing agents' fiduciary obligation. It says it very clearly, much more so than anything else that you will read. And I think that's really an indication to the insurance community that we're needing to take this seriously.
Yeah.
And even more so, you have to understand that most directors and officers' policies will specifically exclude intentional or knowing violations of fiduciary obligation. So when you put all that together, what it's saying is you need to understand the law, you need to implement it in the time that it's required. And if you don't, you become personally exposed because you may not be covered by your directors and officers policy. So that's one step. They give the local building, whether it's the building commissioner or the local building superintendent, it varies by jurisdiction. It gives that office the ability to levy fines and penalties for non-compliance with any of the provisions of the statute, for failing to complete the reports or failing to implement the reports. It also gives the division the same ability to evaluate lapses of lapses under the many provisions of the bill, and to impose fines and penalties therefore as well. So there's a number of layers here that are looking at enforcement. And there's even a fourth layer. I call it kind of a soft enforcement, but it's really by the insurers themselves. As these are going to be public documents. And if an insurer becomes aware that an association is in violation of the law, it's certainly going to manifest itself in, if not requirements to comply or increased rates, but it may also result in non-coverage by that insurer. So it's important that we all know it, that we know what the intent is, and that we get it on our calendars and get it done as intended.
Wow, this is so sweeping, so threatening. And I don't think we've talked a lot about the fact that the reserves issue is going to be very pressing, kind of scary. What happens if a resort has underfunded its reserves?
Well, Sharon, I got to tell you, as I've read this and researched it, it's going to be a very, very, very impactful couple of years here for residents of the state of Florida. There's 1.5 million condominium units in the state of Florida. As we know, so many of those dot the coastline from all the way around the eastern coast through the Keys and back up into the Panhandle. It's thousands of miles of coastline, and we know that they are these shoulder-to-shoulder high-rise condominiums, many of which were developed in the 60s and 70s and 80s, are exactly the subject of this law. And as I noted a couple minutes ago, insurance premiums are skyrocketing. And that's already manifesting itself in rapidly increasing maintenance fees And in many associations, they've had to do a special assessment just to keep up with the insurance premiums, because it's dramatic. Like I say, that's often one of the largest line items on an association budget outside of labor, and they're going up 50% or twofold or threefold or fourfold. So that is already happening and filtering its way and affecting most specifically the people that have fixed incomes, and they're seeing their monthly or quarterly or annual maintenance fee increase. But then in 2024, once that structural integrity reserve study is completed in the 2024 budget, they have to fully fund in cash the amount needed to meet that reserve plan. And if it means that the repairs have to be completed because that phase 2 study was done within 365 days, so in the calendar year 24, they're going to have to be fully paid for in cash in that year. And if not, they're going to have to start fully funding reserves beginning in 2024. The law is very specific that it says that all of these additional components, and I'll tell you what those components are in a moment, have to be inspected and fully reserved for in cash beginning in 2024. Reserves cannot be waived, and reserves cannot be spent, on items other than what they are specifically reserved for. So what does that mean? It means that every association in the state is going to have to really dig into its pockets, because very few, if any of them, contain all of the structural integrity items and all of the major mechanical systems in their reserve studies now. So I think across the board, we're talking dramatic increases in reserve funding beginning in 2024. Listen, it's the right thing to do. Let's step back and remember we're trying to prevent further tragedies like what happened, which was the result of an aging building that wasn't properly reserved or cared for over the years. And there's no way that the legislature is going to allow that to happen again, and we shouldn't as a community. But I think, Sharon, about literally the tens of thousands of folks that own those units, and so many of them are in their 70s and 80s, right? And they bought their oceanfront paradise 2-bedroom condominium 20 or 30 years ago. They paid for it. They get to enjoy their sunrises or sunsets, depending on which beach they're on. And they're even able to keep up with the fees and the taxes and insurance on a fixed income. But thinking forward into the year 2023 but certainly in 2024, when we have to start funding these, actually into 2025, it's 12/31/24. So I'm a little ahead of myself in 2025. They may be getting special assessments that are going to be easily 4 digits or even possibly 5 or 6 to fund these additional reserve components. And it's going to be extremely difficult and impactful for literally tens of thousands of homeowners throughout the state of Florida. So it's going to be broadly impactful, hopefully in a positive way on public health and safety of these buildings, and in the long term on the insurance market. But in the short term, it's going to be awfully difficult for the homeowners that have to shoulder that financial burden.
Well, and for the resorts that have owners who just can't pay, it really is onerous. It's going to be. I wish there was a way to give some kind of emergency relief, but I know that I think you mentioned that it's possible that a resort could lose its certificate of occupancy if it fails to comply or it fails an inspection. So in that event, how could a resort get its certificate back?
Well, it's important to note that the law specifically says that it's not intended to determine compliance with building codes or compliance with fire safety codes. Although they have to reserve to make sure both of those are fully intact, it's not for the purposes of determining compliance. And you think about it, compliance with a building code, there is no jurisdiction in the country that requires a building to update its components to stay in compliance with the constantly changing building codes. But we saw, even in the wake of Surfside, we saw buildings that were evacuated and their certificate of occupancy rescinded by the local building establishment because it was determined that the buildings were unsafe to live in. And that's certainly something that building inspectors are empowered to do throughout the state, is to make a judgment call based on their inspection of the safety of the building. So in the event that the structural integrity, the milestone and the phase 2 milestone study indicate, the structural integrity reserve study indicate that a building's unsafe for inspection, it could certainly lose its occupancy certificate, and those people required to vacate the premises. And obviously, if that's a primary residence, that's going to be a very difficult thing. Yeah. Now, in virtually every condition, there is a repair. You can structurally repair virtually all of the structural components and major mechanicals of a building. You can repair and brace the foundations and the slabs and the structural support in columns and the load-bearing walls and all of those things. But it's extremely expensive, of course, and it's going to vary from building to building. It will vary, obviously, on the age and size of the building and the extent of the deterioration, and the requirement at that point. They will be required to be brought up to modern code, whether it's the windows and doors or the structural components. But it just I'm confident that there will be buildings for which the cost of repairs just doesn't make any economic sense. It's in real estate parlance, it would be functionally obsolete, where the amount of investment required to repair the building basically exceeds the building value itself. So I'm confident that we will see some associations that have to make the difficult decision that they can't repair the building, that they need to tear it down and start over again. But obviously, like I say, for many of them, the work can be completed to make them safe, and it can be done while they're habitable. The key to all of this is getting started and figuring out what the impact is on your particular building.
Yeah, particularly with labor shortage, and I guess materials are more available now than they were a few years ago, but labor is still a big problem.
You're exactly right, Sharon. I mean, just think about the demand for engineers to get all this work done over the next year and a half. They're already getting booked up. I'm dealing with many of them myself, and they're looking at their appointment book and saying, well, how's March of 2024 look for you to do the work? That's how far they're backed up. But you're right. Labor is already in great shortage, as we know. Anybody that needs to field a team of staff at the resort level or in the construction industry knows just how hard that is. But we're still dealing with some of the latent supply chain issues, certainly from COVID, but here in Florida, as in other states that have experienced storms or other natural catastrophes, those areas that are impacted really do suck up so much of the materials resources. If you're trying to source air conditioner units or construction materials, they're very hard to find. They're still very expensive. If you can find them at all. So as with everything else we've talked about, getting started now and getting a determination of what you need and getting in line to get it is really, really paramount. So
do it today.
Do it today, yeah.
Yeah. Sean Tulper had a question. Both the Milestone study and the reserves being fully funded are due on the same date, and December 31. I'll put that slide back up too.
The the milestone study needs to be completed by 12/31/24. The initial milestone study, or like I say, within 180 days of notification by the local building official. And then in the budget promulgated for the following year for 2025 is when you'll really need to fully fund reserves. So I know many associations are doing it now. They're increasing maintenance fees so that they can be funding reserves, or they're planning maybe a multi-year special assessment to try to defray it. But so it will really be in the year after 12/31/24, so calendar year 25, that the full funding of the reserves will kick in. But as we know, for most timeshare associations, the maintenance fee is due at the first of the year on an annual basis. For condo associations, they get to pay throughout the course of the year. So in effect, that 12/31/24 date is the critical date for both items, for effectively for timeshare resorts. But yeah, there's the milestones. They need, really, that fourth bullet needs to say that you need to budget to fully fund reserves in the budget that's promulgated by the end of 12/31/24 for the 25 calendar year.
Okay.
So,
okay.
and the engineering reports can be expensive in and of themselves. I know of one association that did a special assessment just to pay the cost of getting the Milestone and structural integrity reserve study done. So it can be a few $1,000s for a smaller, simpler resort, and then multiples of that depending on the location and the type of facility it is, and certainly the scarcity of engineering resources in that particular area.
Yeah. Wow. That is really, really an interesting dilemma here coming up. Well, Scott, I really appreciate your time. I don't know if anybody else had a question. Sean Tulper, we just won't know the reserves needed until after the study.
That's right. So they'll take the engineer a couple of months once they start, or maybe 60 days to give you back. The engineer or the architect will give you back, here's the components that need to be repaired or replaced, and they'll work with you on the pricing of that. And then anyone qualified to perform reserve studies, and that's a much broader, it doesn't need to be an engineer or an architect. There's a much broader definition of who's able to perform those reserve studies, then need to plug that into the model of what the useful life is of each of those components, the estimated cost, and the funding requirements. But like I say, the ones that need to be funded and paid for in 2025, effectively need to be funded in full at the first part of that calendar year. So get the studies done, folks.
Get going. Oh, gosh.
Yeah.
Oh, boy. Well, Scott, thank you so much again for your time. And I just open-ended invitation to return and update us. I hope we can make that happen. And if there are any further questions, I think we've got Scott's and Jan Barrow's information on the screen, their phone number and email. And appreciate your time, and stay in touch with Resort Trades as well.
Sharon, I really just appreciate to talk about it, because in my career, I really haven't seen an issue that was going to be so impactful on so many people at such a high degree in such a short period of time. So thank you for helping us to get the word out about it. And both Jan's phone number and my email are on the screen. We'd love to talk with anybody. We'll be happy to share the resources that we have in terms of engineering firms and referrals that we could give to you and things of that nature. So
that's very generous.
We'd welcome a phone call or an email from anybody.
Oh, thank you, Scott. And we'll keep you updated also on our weekly e-newsletter, so as much as possible. So please sign up on resorttrades.com. And Again, thank you, Scott, and thank you.
My pleasure, Sharon. Thanks so much for having us today.
And thank you for our visitors, our attendees as well.